one might have thought the creditor was HMCTS. You might not know who the creditor was at all.
Well, one wonders if it's not simply the Crown.
Or it may be the Crown. The Ministry of Justice has always taken the position that it is the creditor in these proceedings, and we haven't questioned that. But so it's an excellent question, my lord. But if I may, I'd like to duck it and say that's a question for the Ministry of Justice, because this case has always been approached on the basis that the MOJ have said we are the creditor.
Well,
it's just that they deny that
I wonder if that's correct. I mean, I appreciate the points you've already made, but I mean, it was your client who chose to sue the MOJ.
Yes.
Now, they could have come forward and said, well, you've sued the wrong defendant, and evidently they've never said so. So they have accepted that they are the correct defendant, and it would have been extremely easy for them to say, well, it's a different government body, or you should be suing the Crown, or whatever, and they've never done so. So at that point I understand, but nevertheless, it was your client who originally selected the MOJ as defendant.
Yes.
Yes.
Oh, so the money is to be paid to HMCTS, and so it is logical that it be either HMCTS or the MOJ. And if you look at the fine itself, is in the supplemental bundle. Maybe that will help. Fine at 6. Overstuffed bundle. How to pay is on the other side. And then under note, all payments must be made direct to HM Courts and Tribunal Service. So it's a fair assumption. There is some question, is it the HMCTS, is it the MOJ? But if one looks at the definition of creditor, we'll come to it in Schedule 12. It's essentially the person to whom you write the check. And here it was HMCTS.
Sorry, I'm struggling to find the reference to HMCTS.
I apologise. On page 51
right.
is how to pay.
Right.
And then there's a note.
All payments must be made direct to HMCTS.
But the fact that the payment is made to a particular party doesn't mean they're the creditor, does it?
Well, creditor is within the meaning of Schedule 12, a defined phrase. And it means the person for whom the debt is recoverable.
Sorry, where is
Where's
that?
that?
Apologise. If one turns to tab 6,
Yeah.
page 70.
The creditor can direct you as to where you are to pay the fine or the debt. Doesn't mean that the recipient is necessarily the creditor. This is an administrative process for collecting.
Yes. I struggle to see who else the creditor could be. I mean, this might just be a matter of public law.
Well, the fine is issued by the court,
yes.
and the warrant of control is issued by the court.
Yes.
So it seems to me that if there is a creditor, it's the court.
I.e. HMCTS. Or do you mean the count that could be the Magistrates' Court at Harrogate?
Well, that's unclear to me.
Yes, I appreciate it's unclear. As I said a few moments ago,
You've got to establish that the Ministry of Justice is liable.
Well, the Ministry of Justice accepts that it's the creditor for the purposes of paragraph 66 in these proceedings.
Yeah, but they say they're not liable.
They say they're not liable because they say no claim can be brought against a creditor unless they cause or contribute to the loss.
So they have not taken this point.
So they haven't taken this point. It would be, as I say, I can't see many other candidates other than HCTS.
As I said earlier, it would have been very easy for MOJ, if they wished to do so, to have said right at the outset, you've got the wrong defendant, and they've never taken that point.
Yes. Well, they've taken the point because they say the defendant can't be the creditor.
Well, yeah, but
but not this
wrong
point.
creditor, but not this point. Exactly. Thank you.
Yes, and as you say, at page 70 of the, and divider 6 of the authorities manual, Schedule 12, paragraph 1(6) says creditor means the person for whom the debt is recoverable.
Yes. Yes.
Yes?
If I may, I'd like to back... Sorry.
What was that?
That's at divider 6, page 70, Schedule 12, paragraph 1, sub paragraph 6.
And of course, MOJ is the sponsoring department for HMCTS, and that may be the explanation.
Yes, I mean, it may be that HMCTS doesn't have separate legal identity. I don't know. Maybe it's not.
Well, it's an executive agency, I think. So it may do.
It may be that the MOJ, for a policy decision, doesn't want HMCTS to be sued in its own court, and so says sue us instead. I don't know.
Right. Okay.
Thank you. So you've taken us to section 76,
Yes.
and you were going on.
To section 125ZA on page 7. Which tells us that something about warrants of control. And in particular, the person to whom it is directed, the warrant of control is directed, must endorse the warrant as soon as possible after receiving it.
I'm really sorry, I got behind again. Where are you now?
I'm now on page 7 under tab 1 of the authorities bundle. We're back at the Magistrates Court Act. We're then going to look at the...
It seems to be implicit in section 125ZA that there must be a paper copy.
Indeed.
How do you endorse a warrant by inserting on the back the date and time when you receive it if there's no paper copy?
I agree. But at the very least, there must be an electronic document that must be endorsable.
Yeah. So the proposition that there never was a warrant can't be right. But I don't understand that to be MOJ's position. I think their position is, although Mr. Trivedi will clarify, that there was a warrant, but for some inexplicable reason, they're unable to produce it.
Perhaps. This is a claim for breach of paragraph 10 of Schedule 12, not a claim for not having a warrant.
Indeed.
Exactly.
Though it's unhelpful that we can't look at the warrant, because in Burton and Williamson, they're going to talk about quite a lot more. It's quite helpful, used by the court in its analysis of what was going on, to see to whom was it directed. And if we could see the warrant, we would see whom it was directed, because it would have been endorsed as soon as possible after they received it. Can I move on to the Tribunal's Courts Enforcement Act then, 2007 Act? That is behind tab 6. And I do so, I'm conscious that my Lord Justice Phillips is very familiar with this legislation because he sat in the court in Burton and Williamson. I've already mentioned, and Burton and Williamson contains a very helpful analysis of Schedule 12. And it'll be my submission that Burton and Williamson resolves this dispute as well, at least ground 1. But with apologies for repeating what the Lordship is
No,
very
you
familiar
should
with.
not assume that you don't need to remind me.
Well, let me start with section 62, enforcement by taking control of goods. Subsection 1 says that Schedule 12 applies, and subsection 2 says you can only use the procedure in Schedule 12.
Yes.
And then over the page, section 63 deals with enforcement agents, which individuals may act as enforcement agent. You must meet one of the criteria. Subsection 2 here, common ground, the enforcement agent had a certificate. 2A. I'd like to move on to Schedule 12 itself, which begins paragraph 1 at page 70. We've looked at briefly. It starts with some definitions. Got the definition of a debt, the sum recoverable, the debtor, person liable to pay the debt, and the creditor, person for whom the debt is recoverable. We've touched on that already.
Yeah, it's for whom it's recoverable, not to whom it is payable. To the extent that that point is still relevant.
Yes, I agree. Then paragraph 2 is something my learned friend is going to place some weight on. An enforcement agent means an individual authorised by section 63(2) to act as enforcement agent. Only an enforcement agent may take control of goods and sell them under enforcement power. And what that means is that creditors can't use Schedule 12, only enforcement agents can. So the enforcement agent is doing something that a creditor cannot do. I accept that.
we had some debate in Burton and Williamson as to the extent to which a High Court enforcement officer
Yes.
could act as an enforcement agent.
And you concluded that they could not. Because the court concluded that they were not individuals authorised by section 63(2). We don't need to go over this because this isn't a High Court enforcement officer case, but that was the conclusion the court reached. Moving on to paragraph 3, further definitions. Some to highlight. Goods, meaning property of any description other than land. Interest, defined as being a beneficial interest. And then over the page, subparagraph 2, we have references to 2A on page 73, references to goods of the debtor or another person, references to goods in which the debtor or that person has an interest, i.e. a beneficial interest.
But that's all not in dispute any longer.
Nope,
It's
not in
accepted that there was no beneficial interest in the
Yes,
car.
exactly. And therefore, moving ahead, the paragraph 10 was breached
Yes.
over page 74. There's one other provision, paragraph, to show the court by way of background before we get to paragraph 66, which is where my first ground will begin. And that's paragraph 62 on page 81. And this provides for regulations which allow for the recovery in respect of cost of enforcement-related services. We don't need to look at these regulations. It's the taking control of goods fees regulations. It's important to know that enforcement agents are entitled to charge, to levy fees for the work that they do, and the further along the enforcement path they go, the greater those fees are. There are 3 stages: compliance stage, after receiving instructions, an enforcement stage, and the first entry on the premises, the first attendance on the premises, and a sales stage. And that takes me to paragraph 66, which is where I'll begin ground 1. I think I'm going to do 3 things with ground 1. I'm going to first read this paragraph with the court, try and construe it, then I'll look at CS and Marston, and then the national standards. But it's probably helpful if the court reads paragraph 66 in full. It goes over the page. So this is the paragraph under which I say a creditor is liable for a breach of Schedule 12 causing loss to the debtor. I thought I'd comment on the paragraphs line by line. So the paragraph applies when the enforcement agent breaches a provision of the schedule. That's where we are. The breach was of paragraph 10, but it wouldn't make a difference if it was any other paragraph. Breach, this is subparagraph 2, does not make the enforcement agent or a person he is acting for a trespasser. And I emphasise those words because it implies there might be someone else for whom the enforcement agent is acting who might be a trespasser, which is interesting because only enforcement agents are able to attend the premises. So if this is trespass to land, then only the enforcement agent is going to be there, or people he brings along, but wouldn't necessarily be a person that he is acting for. 3, the debtor may bring proceedings under the paragraph. That's what happened. 4 tells us where the proceedings may be brought. We're under 4C because we're dealing with a magistrate's court fine and the magistrate's warrant of control. So this application could have been brought to a master in the King's Bench division. Given the cost, the amount at stake, it was perfectly logical to bring it to the county court. 5 gives 2 types of remedy which the court may award in these proceedings. The first is a proprietary remedy, to order the goods to be returned to the debtor, e.g. to release the clamp on a car. Interesting that there's no respondent to this. So presumably anyone who holds the property could be ordered to release to return to the debtor. One might imagine a situation of an auctioneer who's holding on to the goods, about to sell them, but they can be ordered, you must return them to the debtor. And 5b is what matters most for our purposes. Order the enforcement agent or a related party to pay damages in respect of loss suffered by the debtor, and the related party is either of the two. 6a, the person on whom the enforcement power is conferred. For example, a High Court enforcement officer. We're going to look at Burton quite shortly. B, the creditor. And I will be arguing very shortly that it's 6b that brings in the creditor and makes them directly liable. Just finishing the paragraph though, subparagraph 7 says that subparagraph 5 is about prejudice to any other powers of the court. Now, I think that means that the court could, in an appropriate situation, give declaratory relief, for example, maybe an account of profits if the conduct justified it, who knows. But the default remedies are A and B, proprietary and personal. 8 gives a very wide-ranging defence of reasonable belief, which seems to be binary. It seems to be the case that if the enforcement agent has a reasonable belief, then there's no claim whatsoever, regardless of how much damage was caused. And 9 is a very specific carve-out that isn't actually relevant here. There wasn't a breach of paragraph 58.3, but it concerns where the creditor has been paid in full. But enforcement goes ahead. So, the question for construction for this court is, did Parliament intend for creditors to be liable to pay damages under paragraph 66, even if they did not cause or contribute to the loss? Now, Mr. Burton's case is quite simple. That's what the words say.
Well, as you point out in your skeleton, in one sense, they always cause the loss because they set the enforcement process in motion.
Exactly. So, if but-for causation is sufficient, then yes. If you're looking for something a bit more substantial, but-for causation isn't always enough, then in most cases they won't. But I'm arguing here the MOJ obviously was the but-for cause of the loss, but there weren't any employees of the MOJ on the scene who could be criticised for causing Mr. Allen to clap the car.
Well, why? If you're right, then it could very simply have been done by providing that the creditor is liable for any breach by the agent.
Yes.
It doesn't do that.
It's not that far off that. It says the court may order the enforcement agent or a related party to pay damages, and related party is one of these two. And the court in Bone held that under 6A, the HCO is vicariously liable for every act of the enforcement agent. I'm going to look at that in just a moment, if that answers your question, my lord.
But what about the creditor?
Bone didn't address the creditor, no doubt in there, but the structure of the section is the same. It's a related party, and there are two types of related party, but at least one type we know indisputably is liable.
Yes. But what it says is that the court may order.
Yes, I brought something to say about this may. It doesn't confer a pure discretion. That is to say, it doesn't make sense that it's just a court may, if it's just and equitable, do what it wants. And I say so because it'd be quite strange to say the court isn't going to award damages against the enforcement agent. The enforcement agent's the one there committing the tort. And the may is up there at the top in the proceedings of the court may, A-B. It'd be quite strange if someone wrongly took goods for the court to decide as a matter of discretion. It's not going to order the goods to be returned to the debtor, unless perhaps they've been sold or something like that.
You're saying may should be interpreted as meaning has power to.
Has power to, and will if it's a good claim. I mean, let's say that the words would must, that wouldn't make sense, because it's not the case the court must order the goods to be returned. There are circumstances in which you won't. And it may be that the proceedings are bad, but it may be that the goods are sold, and so the third party shouldn't be required to return them.
So has power to A, order the goods to be returned, and or B.
Yes, without prejudice to any other powers of the court, and or something else. Exactly. Please.
This envisages that the court may, or has the power to, order damages just against the related party and not against the enforcement agent.
Yes, and indeed, we're shortly about to see that Lady Justice Elizabeth Lang implied that the application ought to be made against the HCO to the exclusion of the enforcement agent in a High Court writ case. But I would say you have a choice. You can choose who to sue. And as between the two, if the creditor is the one really at fault because they caused the loss, then there'll be a claim for an indemnity between the enforcement agent and the creditor, or between the HCO.
How could the creditor cause the loss distinctly from the enforcement agent? In a way that wouldn't have given the enforcement agent a reasonable belief.
Yes. I think that's a question better asked to the MOJ. I don't say there's any such requirement. But hypothetically, one can think of a situation where, I don't know, all the situations I can think of would trigger the reasonable belief defence.
Which then would exculpate the creditor, so
yes,
it defined itself away.
Yes. I think that's a point that supports my reading, my lord. I'd like to turn to Bone and Williamson, which says something about 6A, the related party, if that related party is a High Court enforcement officer, which in the acronym is HCEO, just when the court looks at the case. This is behind tab 33. I might say something quite briefly about the facts of the case, just before I begin. So this is a case, it's about fees. An enforcement agent levied too much fees. And a claim for fee assessment was brought against the HCEO, the officer, previously known as a sheriff, and not the agent. And the question was he the correct respondent? And one of the arguments made there was that he must be the correct respondent because a fee assessment is a bit like a paragraph 66 claim, where the claim is for breach of paragraph 12, i.e. taking too much. And so Lady Justice Elizabeth Lang discusses the relevant liabilities of HCEOs, the person on whom the enforcement powers conferred, and High Court enforcement agents. The court reads page 668, paragraphs 84 and 85. So there's now authority that if the related party is the HCEO, i.e. the first of the two related parties, then that related party is, quote, jointly and severally liable as respect to things done by the agent acting under Schedule 12. And the court here held it as clear as it can be. I'm now reading from paragraph 85, clear as it can be. Paragraph 66.5 gives the debtor a choice when he claims that an agent has breached the provision of Schedule 12, bringing the claim against the officer or the agent. And the structure of paragraph 66 is the same. The court looks back at page 82, back to paragraph 66. This is page 82, the sort of page it's helpful to have a sticky tab in.
Yes.
So I thought I'd say something about why Parliament might make creditors liable for damages that they didn't cause themselves. Two reasons, I think, in my submission. The first is to ensure compliance with the Act. And the second is to have a fair balance of risk in the event the enforcement agent can't pay the liability. Taking those in turn, compliance with the Act is necessary because there is an imbalance of power between enforcement agent and debtors. debtors are likely to be poor, unable to access legal advice, and that creates an obstacle for providing proper supervision of an enforcement agent, who at the same time has tremendous power under Schedule 12 to take control of goods. They have private incentives. They get paid more if they do more. And the entry standards are quite low. There's a GCSE equivalent mandated by the practice direction on the certification of agents. The courts note that's practice direction 84, paragraph 21E. So from a social perspective, it's difficult to ensure that the enforcement agent complies with the schedule without some form of oversight. It isn't likely to be imposed by the debtor themselves.
But it would be imposed by the High Court Enforcement Officer, wouldn't it?
Yes. So in the case of a High Court writ, there will be someone else looking over the shoulder. But in a case...
But that doesn't apply here because there is no High Court writ and there is no High Court Enforcement Officer.
Exactly. In the majority of cases, if one looks at the figures, there are 200,000 odd warrants.
Yes, but forgive me, the point is that paragraph 6, subparagraph 6, applies to both cases.
Yes.
So it must be interpreted the same in both situations.
So it would be sufficient for my purposes if 6A and 6B were alternatives. You can only sue the High Court Enforcement Officer if there isn't a creditor. Wrong, other way around. You can only sue the creditor if there's not a High Court Enforcement Officer.
But
that would be sufficient.
You can't get that from the statute.
No, I think that's a very strange reading. I think the more natural reading is that you
must,
any related party.
You must say that even if there's a High Court Enforcement Officer, well, perhaps you don't say it. You just said that you don't say it, but on the face of it, even if there is a High Court Enforcement Officer, the creditor is liable.
Yes, I don't shy away from that. But that's the MOJ's own guidance that we're about to look at.
That is, you're going to come on to Lord Leggett.
Yes, I'm going to come into Lord Leggett. I'm going to look at how you can read the words caused or contributed, and then I'm going to turn to Lord Leggett. That's my sequence. Yes, I was going to say something about Kafagi and JBW, which we don't need to look at, but it's a decision of this court, pre-2007 Act enforcement, which held that the enforcement agency isn't necessarily vicariously liable. They say it's a matter of fact. And so there will be no one else. There's the HCO if you're in a High Court writ situation, but there isn't necessarily an enforcement agency. And the solution is to require the creditor to be liable.
And there we're talking about parties like Marston's.
Exactly. Exactly. And quickly on the balance of risk, I'd say that it's fair that the creditors bear the risk because they're the ones for whose benefit it is that anyone enforces a writ or warrant of control.
But the creditor is unlikely to have insurance.
Yes, unlike the HCO. And so you can choose, from the perspective of the debtor, one can choose who's the right party to sue, and as between them there can be a contribution or an indemnity.
And the parties who are going to have insurance will be the HCEO,
yes,
is involved, the companies such as Marston.
Potentially. Maybe.
Well, I have to assume that they will probably have insurance. Might be expected to. And possibly the enforcement agent.
The enforcement agent has a £10,000 bond.
Yeah. But the creditor, who probably play no part whatsoever in this activity, will not have insurance. Unless there are, well, certainly not insurance against misfeasance of the enforcement agent.
Well, I take issue with the phrase "take no part whatsoever." We're going to see that the MOJ's guidance is that creditors ought to take a part in it, and that's the DCLG guidance too. And the way that they manifest their control is via a contract, and so they do have the ability to control the enforcement agent. And I will come on to CES in just a moment. But before I do, I wanted to look at the reading that says cause or contributes. Because what that posits is that, looking back at subparagraph 6, related parties either of the following: person whom enforcement power is conferred, or the creditor, brackets, if they caused or contributed to the loss. We think that's quite a difficult reading. There's no reason to distinguish between 6A and 6B.
So does that wording come from anywhere in particular?
Sorry?
Does that wording come from anywhere in particular?
From the Ministry of Justice's submissions.
Just from it, they haven't taken it from it. That's just their
I think
formulation.
Yet again, a question perhaps for the MOJ. But we think cause or contribute conceptually is quite difficult. Causation doesn't normally render someone liable for damages unless it's normally neither necessary nor sufficient. Someone who's vicariously liable didn't cause the loss, and someone who caused the loss but didn't owe a duty of care isn't liable at all either. So conceptually, it's strange to say that causation would be sufficient in the absence of a duty of care. Where's the duty of care? Contribution falling less, that amounts to something less than causation, is normally irrelevant as well.
Well, presumably what they mean is cause or contribute to the breach.
Perhaps, yes. But if causing and contributing to a breach doesn't normally render someone liable, to give a slightly silly example, if a friend takes a surgeon out to a pub shortly before an operation and they have some drinks, he would have caused and contributed to the damage caused in the operation held shortly thereafter. But in the absence of a duty of care, the friend can't be sued for personal injury, even though he's caused or contributed to the breach. He was the one feeding drinks to the surgeon. Maybe that's a silly example, but it illustrates the point. Causation is not sufficient, normally. And contribution is normally something one considers between joint tort pieces. That's a different concept altogether.
I think it's probably meant in the sense of contribute to the loss, also be responsible for a part of the loss. Maybe?
Perhaps.
But the situation we'll be talking about is where the creditor says to the enforcement agent, I know that the debtor has got several very valuable cars.
Yes.
Parked in his drive. But he knows, or has reason to believe, that some or all of them are on hire purchase. And when the enforcement agent gets there, he's told that they are on hire purchase. And so both of them do not have a reasonable belief.
Yes.
But the creditor has specifically identified them to the enforcement agent as assets to be controlled.
Yes. So that would be an example. It's an interesting example because you might well say that the creditor drops out the picture once, as here, the debtor turns up and says, here's my hire purchase agreement. These cars are hire purchase. At that point, the reasonable belief formation would more be determined by the facts on the ground, the interaction with the debtor, than what happened with the creditor. But maybe that's an example, my lord.
Or one can refine it.
Or one can refine it, perhaps. But that just illustrates my next point, which is that there are practical difficulties. You're the debtor. You know something's gone wrong. But how are you meant to know whether that was caused by the creditor or the enforcement agent? Particularly in the context of what's likely to be quite a low-value claim, because we're talking about a chattel, essentially. That would be imperfect. And there's the question about how liability is meant to be split between the enforcement agent and the creditor. I don't know if the MOJ's position is that some small contribution creates 100% cost exposure, 100% of the loss, or if it's meant to be apportioned to their contribution, in which case you might need to sue both to recover 100% of the loss. It strikes me as quite difficult.
But that arises on your construction as well, doesn't it?
No, on my construction you can sue everyone for everything, and then between them there can be an indemnity, my lord, or a contribution between the two. So you can even if the creditor is not at fault, you can sue them for 100% of the damages caused. And I think that's the simple reading. Order the enforcement agent or related party to pay damages. So here, ex hypothesi, the application is only made against the creditor, as happened here. The related party to pay damages in respect to the loss suffered. And the creditor can then recover that loss, if it's not their fault, from the enforcement agent. And we will shortly see that there is an indemnity in the contract between the MHA and Marston, so it's not mere hypothetical. It can be done.
Why didn't Mr. Burton sue the enforcement agent as well?
It's difficult to sue enforcement agents, my lord. It's difficult for a few reasons. Firstly, they're often quite hesitant to give out their addresses, understandably. Well, I understand why on both sides. You need to know where the person is to serve them the claim form. But if you're a bailiff, you don't go around telling everyone where you live. So practically speaking, it's difficult, my lord. There's also the problem about who has deeper pockets. An enforcement agent with a £10,000 bond or the creditor in situations when there are very many warrants of control issued to enforce liability orders, i.e. against local authorities, or court fines. The deeper pockets are with the creditor.
It seems strange that a debtor couldn't find out from the court that issued the warrant the address of the enforcement agent to which it issued the warrant.
Well, not necessarily the home address. There might be a professional address.
Well, why would the court know? Because the court has no idea who the agent is.
Well, the court knows who all the certificated agents are because they've
Yeah,
been
but
they will know that this specific.
There will be hundreds of those. So
There are.
how do they know which one? They don't.
The court wouldn't know which one enforced any warrant. No, it wouldn't have a clue.
No.
All the court knows is the list of certificated agents. It's
I mean,
online.
even the MOJ didn't know at the time because that was a matter between Marston and the agent selected by Marston.
Yes. Yes. I'd like to move on to CS and Marston, which is at the heart of the MOJ's argument. This is behind tab 31. I'll let the court read the head note, then I'll summarise the facts, and then I'll go to the relevant passage. So in my submission, this case is meant to be authority for the proposition that an HCO is an officer of the court and not an officer of the creditor, an agent of the court and not an agent of the creditor, and therefore my construction of paragraph 66 is somehow absurd. That's how it's going to be used. And I don't agree this case is relevant, and I don't agree that is the correct proposition of law to be derived from this case. It's a case about competing writs. You have one debtor with two judgment debts, two writs of control. The first writ was enforced first in time by way of control of the goods agreement. Second enforcement agent comes along under a second writ, threatens to take control of everything, even those covered by the controlled goods agreement, and is paid off. And then enforcement agency 1 sues enforcement agency 2, saying, we should have been paid first, we were the earlier writ, he's handed over. And the relevant passage can be found on page 609 of the bundle.
And just before we look at that,
yes,
my understanding
yes,
is that from first to last, there's no mention of paragraph 66.
Exactly. Exactly. before any discussion of the liabilities of the High Court enforcement officer, the creditor, or the agent. Yes.
Well, and also, as you pointed out already, this was about writs of control,
Yes.
not warrants of control.
Also that.
And hence the focus on the position of the HCEO.
Yes, exactly. I did make one mistake in my skeleton argument. I said this passage was obiter, but in reflection, I don't think it was. There was an argument made that paragraph 50 of Schedule 12, on a true construction, meant that the second writ could still be paid first. And paragraph 50 is quoted in paragraph 71 on page 608. And Lord Legate is discussing the correct construction of paragraph 50. I'd then invite the court to read the passage from 76 to 81, black line. So Lord Legate doesn't say the enforcement officer is not an agent of the creditor. If you look at paragraph 80 and read it carefully, Lord Legate says that it's wrong to regard the enforcement officer to whom a writ of control is directed simply as an agent of the creditor whose judgment of debt is issued to recover. And then in paragraph 81, Lord Legate refers to Hooper and Lane. Lord Crenworth says, quote, "The sheriff, though for some purposes an agent of the party, who puts the writ in his hands, is not a mere agent." So I don't accept that this is authority for the proposition that an enforcement agent is an agent of the court to the exclusion of the creditor. What's happening here is an ex parte James argument. Lord Legate is saying that when you're construing paragraph 50, the amount outstanding, you should remember that we're dealing with officers of the court who must act honourably. And so when they say the amount outstanding, that must be the amount outstanding under the first writ. And so because they act not merely as agents of the creditor, a normal agent must jump when the principal says to jump. But that's not true of officers of the court. One can think of an example of a solicitor, for example, no doubt an agent of the party, no doubt an officer of the court. But there are some things a solicitor will not do for their client because it's professionally improper, because of the obligations imposed as officers of the court. My lord, were you? Ah, sorry. So that's what's happening in this passage. But, and as my lord, Lord Justice Arnold, has commented on, it's not a paragraph 66 case at all. And so it's of no relevance here, is my submission. But I also have some difficulty with the logic here, because if it's the case that enforcement agents are not agents of the creditor, they're only agents of the court, well, why should creditors be liable if they cause or contribute to the damage? That doesn't make sense. It should be a complete cut-off if they're simply acting on behalf of the court and doing nothing else. But that's not what the MOJ say. The MOJ accept that there can be liability, albeit if it's caused or contributed. That's all I had to say about CS and Marston. Unless,
well, just to be clear, I think one also needs to pick up paragraph 122.
Yes.
Don't we? Just where I think it makes it plain that the point that's being made, for its relevance, relates to enforcement agents acting under an enforcement power just as much as enforcement officers.
Yes, so I made the point in my skeleton argument that maybe enforcement agents aren't officers of the court. I wasn't going to...
Well, it's difficult in the light of both of these passages, isn't it?
Well, I wasn't going to push the court on that today. I mean, it strikes me, I'll say this, it strikes me as odd to the slightly Victorian concept of an officer of the court that bailiffs, thousands and thousands of bailiffs with their GCSE equivalent certifications, are officers of the court. It seems, it rankles with me, but maybe they are, and nothing turns on it in my argument today.
Well, I see your point, because the court has, as we've discussed already, has no idea who the agent is. I mean, it's completely different to the officer,
yes,
where a named person
yes,
is appointed as officer by the writ.
Yes.
Whereas on a warrant of control, the court issues the warrant, has no idea at all
yes,
who the agent is, who's ultimately going to be entrusted with executing that warrant.
Yes, I agree with that. That's one of the reasons in my skeleton argument for doubting it. And you might think about a liquidator, an officer of the court, who was appointed for one specific liquidation. The court knows who its officers are. It seems surprising that in all the there must be millions of writs issued every few years, that there is not authority that a bailiff, now enforcement agent, is an officer of the court. But I don't think much turns on it, because I say this isn't a paragraph 66 case.
We say no authority except Lord Leggett says so expressly in paragraph 122. And any
yes,
other enforcement agent acting under an enforcement power is, for relevant purposes, an officer of the court. Not sure we can get much higher authority than that.
Well, I'll say that he didn't hear argument on it, as it relates to enforcement agents outside of a writ of control.
Well, the wording of a writ of control and the wording of a warrant of control issued by the court, providing a power that doesn't exist otherwise, is pretty much identical, isn't it? And it would be strange if somebody exercising that power under the warrant of control didn't owe any of the obligations of an officer of the court in so exercising what is a quite otherwise extraordinary power.
Perhaps, my lord. I mean, I don't want to get too distracted by this, because, as I said, it wasn't something I was going to place weight on in my oral submissions.
No, the only reason I pick it up is because there is a suggestion that there is some marked difference in this case, because it was an enforcement agent rather than an enforcement officer. And whilst, of course, there are different situations, for my own part, I can't see why that distinction makes a difference to the construction of 6b. Yes,
and it would only be the slightly implausible idea that 6a and 6b are to be read disjunctively when there's nothing in the section to suggest it. But that is one.
That's not your primary argument.
It's not my primary argument.
Yes, thank you.
I was moving on from CS and Marston then. I was going to say something about the MOJ's contention that a creditor is limited in the manner in which it can control an enforcement agent. Because it's correct to say that an enforcement agent can use a Schedule 12 power and a creditor, unless they're certificated, cannot. First thing to say is it's odd that the MOJ make this policy argument almost, when the MOJ's own policy, as we're about to see, is that creditors are responsible and accountable for the agents. Taking it at face value, I've got two things to say. The first thing is that this argument was considered in Bone and Williamson and dismissed. If the court goes to paragraph page 670, on tab 33.
I beg your pardon, which paragraph?
88,
Thank you.
page 670. Lady Justice Elizabeth Lang is considering the contention that it's simply not right to impose liability on HCEO when the HCEO didn't have the power to act as an enforcement agent does, much like a creditor doesn't have the power to act as an enforcement agent does. And she rejects it, because it's a straightforward consequence of the statutory scheme. It doesn't depend on any appeals to the general principle of the law of agency. So I sketched out in my skeleton argument how you can view an enforcement agent as a quasi-employee. You can view them as a principal-agent relationship, both established examples of vicarious liability. But I don't need to, because the point is it's a straightforward consequence of the statutory scheme, and that analysis is helpful just to show that it's not an absurd reading to hold the creditor vicariously liable.
Would you say it's an automatic liability?
Yes.
Which arises simply because he's the creditor?
Yes.
Well, and a breach, obviously.
And there's a claim to be brought, yes.
Automatic liability.
Automatic liability. Or to reuse the words of Lady Justice Elizabeth Lang, jointly and severally liable as respect things done by the HCEA under Schedule 12. That's from paragraph 84. That's what she says about the HCEO, and that's why I say also applies to the creditor. I'd like to say something about back to the MOJ's argument that there's no ability to control a creditor. Well, the first thing I say is that you don't need the ability to control by using his powers. That's what Lady Justice Elizabeth Lang said. The second thing is I do reject the premise that it's impossible to control an enforcement agent, even if a creditor doesn't have Schedule 12 powers, because they can contract with the enforcement agent. And through that contract, they can control the enforcement agent. I like to take the court to this contentious DCLG guidance. That's behind tab 47. Page 919.
And the point is that this is the Department for Communities and Local Government.
Yes.
We find that on page 912.
That's right. And this was produced before the enactment of the 2007 Act came into force in April 2014. It was written with the national standards in mind, and it often quotes the national standards. Not quotes, but it refers to them. And it's page 919, paragraphs 4.1 to 4.5. The local authorities very often use bailiffs because to enforce unpaid council tax. It's a matter of great importance.
Now, this is a piece of terminology which puzzles me, and forgive me for raising what may be a red herring, but I'd like to establish it is a red herring and get it out of the way.
Yes.
Am I right in understanding that documents like this continues to use the word bailiff, when in fact that terminology is obsolete and they should be referring to enforcement agents?
Yes, I wouldn't criticise the DCLG because this was written before April 2014.
But obviously with a view to what was going to happen.
With a view to what's it's been on the book since 2007.
Yeah.
It wasn't in force. Yes, bailiff. Enforcement agent is something of a euphemism. I mean, it's the statutory word, so I use it. But the word bailiff really is what should be in the court's mind when thinking about.
Well, what is it though? That's partly why I want to ask the question.
Okay.
Because, I mean, that may still be the commonly used word. I'm sure that most members of the public who've heard of bailiffs will have no idea what an enforcement agent is. So that I can understand it from that perspective. But the reason why the statutory language is important is because we have a statutory code now.
Yes.
and therefore, to a large extent, not entirely, as we see from CES and Marsden, but to a large extent, it's regulated by statute, and therefore one has to be cautious about bringing into the statutory regime mental baggage from the common law associated with the word bailiff.
I accept that, my lord. I accept that.
Anyway, this is guidance that was forward-looking, you would say.
Yes. And it says bailiffs are simply working on the local authority's behalf. The local authority's responsibility to ensure bailiffs, directly employed private companies, are working within the law. The local authority can be held accountable if they're not. This is before paragraph 66. And actively managing contracts is where DCLG sets out its expectations.
Which is the specific part that you rely on?
4.1 and then the 4.3. Well, really it's the heading, actively managing contracts, my lord. The details don't really matter. This is just in response to the contention that it's impossible to control an enforcement agent because the creditor doesn't have powers.
Well, it supports you on 2 points. First of all, it's support for the proposition that creditors are accountable
Yes.
If the bailiff is not within the law. And secondly, that there is a way of controlling the bailiff, namely by contract.
Exactly.
So you think that 4.1 is referring to paragraph 66?
No, as I said, this is a this came out, I think, in 2012. So after the 2007 Act is on the books, but it wasn't enacted until 2014.
Well, it says June 2013.
Oh, I beg your pardon, 2013. Thank you, well spotted. Either way, before April 2014, which is when paragraph 66 came into force. This paragraph 66, I say, is, it doesn't come out of nowhere. This was the position in 2013 according to the DCLG. But really, it doesn't address the construction of paragraph 66. It goes to the MOJ's argument, which is that my construction is absurd.
Just going back to what you were talking about earlier,
Yes.
I see on page 915, paragraph 1.4, it refers to the publication in January 2012
Yes.
of an updated version of the National Standards for Enforcement Agents,
Yes.
which places new emphasis on the role of the creditor.
Yes.
And so that supports the proposition you were making earlier that first of all, this is referencing the national standards, albeit not the version that we have, because we've got the April 2014 version.
Yes.
Which is logical, given that that's what came out when the Act came into force. But also, again, it reinforces the point about the role of the creditor.
Yes. Exactly. And given the time, I was going to look at the contract with the MOJ, but actually I'd rather stick to the national standards. The court's motion, which is at tab 48. April 2014, 6th of April. And at page 94, I'm going to be looking at paragraphs 1 through 7, but particularly those marked on the left-hand side.
I'm sorry, could you repeat that page?
Behind tab 48,
Yes, page.
924.
Thank you. Clause.
I'm going to, all the section marked on the left is the, but 7 is the most important, but you can get to 7 via numbers 1 to 6.
should we be clear that this is not referring to, this is not dealing with creditors generally, is it?
It is.
It's dealing creditor.
Creditors is defined in paragraph 4. Local authorities, major or frequent judgment creditors, government departments, HMCTS, and landlords. But it does hear the words "this includes." So I read this as saying, I'm sure the MOJ will forgive, a private individual who gets a warrant of control in the county court and doesn't know about it, but this is for all creditors. It says intended for the
Well, I understand this is certainly primarily addressed at
major creditors.
the large, frequent judgment
Yes.
creditors, which is going to be local authorities, maybe banks,
Yep.
other financial institutions.
And HMCTS, to
HMCTS.
whom financial penalties are paid.
Yeah.
It's those words that I emphasise because that means this guidance expressly refers to
Yeah.
this case. It's an HMCTS case.
I think the point I'm making is this: if you have guidance addressed to these major creditors, understandable you would have guidance for them, but you can't construe a provision that relates to all creditors in the light of guidance which is addressed primarily to major creditors.
I don't know about that, because if the challenge is my construction is absurd, and I think that is the challenge, then I don't see why it's irrelevant that the MOJ says this is what we consider to be, quote, minimum standards. I take that from paragraph 2. It's minimum standards for a major creditor, I agree. The fact is that major creditors have more ability to control the judgment creditor, so that the enforcement agents, because they'll spend more time thinking about how we're going to do this best, whereas your average county court judgment creditor.
Ministry of Justice thinks it's appropriate to set out minimum standards for certain types of large creditor.
Yes.
That is a completely different thing to what is the construction of whether or not any creditor has liability under paragraph 66. And indeed, one of the reasons you may well need this minimum standards is because the statute doesn't specifically deal with what is to be expected of the creditor.
I'm not sure. This document is a mix. It has some guidance. It has some law. For example, if you look at just to see what we have, doesn't matter, but just so the court understands what this document is. If you look at paragraph 19 and then paragraph 20, the guidance is saying things which it might be a loose assessment of the law, but it is the law. What it's saying isn't something above and beyond the law. It's saying you must act within the law and you mustn't be deceitful, i.e. you mustn't commit fraud. And at the same time, it has guidance which is perhaps better described as guidance. For example, 24 it isn't something which is imposed by the law. There's no requirement not to be press debtors to make unrealistic.
I mean, I have to remember that local authorities, banks, and other financial institutions, and the government bodies are all subject to ombudsman schemes.
Yes.
And those ombudsmen would be the first port of call, one would have thought, for members of the public to enforce minimum standards.
Yes. I'm sorry, my lord. I don't quite. I mean, I agree with that. But I'm not sure.
Well, I'm just wondering how this really helps us in relation to construing the statute. It seems to me that this guidance isn't really directed at that, and also if it expresses a view on statutory construction, how that helps us in any way, because either it's right, in which it doesn't add anything, or it's wrong, in which case it's wrong.
Yes. So
it doesn't. This isn't a statement by a body expert in the law as to the construction of the statute.
I agree with that.
It's providing guidance as to how major creditors should deal with their
Yes.
enforcement actions.
So I have a passage in Bennion on statutory interpretation that discusses how the court deals with guidance. More or less, the bottom line is the court should construe the statute as it sees fit, but it may be reassured to know that the guidance agrees with it.
This isn't guidance as to statutory construction, is it?
No, it's not. It's national standards for use.
And does Bennion deal with that?
Well, not precisely, no. If it helps, we can look at the passage in Bennion, but I have nothing novel to say about statutory construction, my lord, so if the court doesn't find this helpful for purposes of statutory construction, then...
well, other members of the court may find it helpful, see.
Right. I'd say one other thing about one use of this document that falls outside the exercise of statutory construction. What we have is a very strong statement of policy, at least as it applies to major creditors, expressly including H and CTS. And it's that creditors should remember that enforcement agents are acting on their behalf, responsible and accountable. And that must mean, surely, that if an enforcement agent is in breach and causes loss, one can claim against the creditor. That's what paragraph 7 means. Otherwise, words responsible and accountable are empty. But my learned friend doesn't say that this reading of the national standards is wrong, and rather what the MOJ's position, which is taken without any consultation, appears to be that the national standards guidance document itself is wrong, and it seeks to resolve from that in response to a very low-value claim made in the county court in Hull, the moment it itself is the respondent to an application under paragraph 66. I'm not making a public law challenge. I can't make that in this court, although were I be asked, I would say one would be successful. But there is another use, which is to say that the MOJ is holding itself out, holding H and CTS out, as responsible, i.e. as liable. And so there is an assumption of responsibility, which is relevant for this court to know, because it's an alternative route outside paragraph 66, with which the MOJ could be held liable. So the general rule is that one party isn't liable for torts committed by another, but there are exceptions for the assumption, the voluntary assumption of responsibility for that third party. It's in this context I'd like to turn to the decision of the House of Lords in Smith and Littlewoods. And it's a back to first principles argument, I'm afraid, which is why we're looking at Smith. It's behind tab 14. The underlying case is about a cinema that was left unattended. Some teenagers broke in, set fire to the cinema, fire spread to a nearby cafe and church, and the owners of the cafe and church tried to sue the cinema owner, saying you should be responsible for the arson caused by the vandals. Lord Gough has a summary of circumstances in which a defendant can be responsible for injuries suffered caused by a third party, and that's at page 300 of the bundle. It's a back to first principles argument. What I'm saying is that there can't be a clearer case of a special relationship between the creditor and the third party than the creditor, between the debtor and the third party, than an express assumption of responsibility. The MOJ says HMCTS is responsible and accountable. That's a minimum standards. And therefore it is. The MOJ can't tell the world, or at least tell all major creditors, you should be responsible and accountable, and so are we, and then resolve from that the moment a claim is brought. I'd like to say something about the two capacities argument, which seemed to have some traction before Her Honour Judge Richardson, and that's that the MOJ allegedly acts in two capacities, sometimes as a creditor and sometimes as a policymaker. Well, I don't accept that. At all times, the MOJ is a public body. At all times, public law applies to it. Sometimes it carries out activity to which private law applies, but that doesn't make a difference. And even if there were instances when private law applies, it's not going to be now when enforcing court fines, because that's obviously a public function of the MOJ. And the last thing to say about the two capacitors argument is that it asserts that the MOJ is entitled to make guidance for others, but not for itself. And I say that simply isn't true. The MOJ must be held to the same minimum standards as any other creditor. Say one thing about the reasoning of Judge Burton, and then I'll move on to ground two. Judge Burton appeared to apply some test of causation in her extempore judgment, and Her Honour Judge Richardson made two conclusions from that. And the first is that there was an implied rejection of my client's argument about strict liability, and the second is she concluded that that decision was irrational. And there is another way to read Judge Burton's judgment, which is that she really was applying some sort of but-for causation, which, as we've discussed, will always apply. Because every time there is a creditor gets a warrant of control, there will be a but-for cause of the loss. That concludes my submissions on ground one, unless the court has any other questions. I'd move on to ground two.
Just clarify one thing.
Please.
Are you saying that you have a claim outside of paragraph 66?
Well, was what you said earlier.
Yes.
You
No,
said,
I
you said an
understand that.
alternative route outside paragraph 66.
As the paragraph 66 construction argument is what I meant to say. But yes, I'll bite the bullet, yes.
And is that a claim that's been pleaded in advance? Right.
Well, there was serious emphasis made on the MOJ's national standards in submission and in the skeleton argument before Judge Burton. So,
yes, that's not normally how you advance a claim.
Yes, I mean, the national standards is not quoted in the application notice, no. Application notice is very terse.
Am I right in thinking that because of the value of the claim, there were no pleadings in this case?
That's right.
And one of the difficulties about that is that is there any suggestion that Mr. Burton knew about this statement that there was any? I mean, the assumption of responsibility has got to come from a relationship between the parties, hasn't it?
No, I'm not sure that's right. I mean, Lord Gough refers to there being a special relationship between, rather than assumption of responsibility, but special relationship. If one thinks of Dorset Yacht, the case of the Borstal boys, supervised by the Home Office, I mean, you don't know who's supervising. So if someone smashes up your yacht, you don't necessarily know that that's because the Home Office were in charge and they made a mistake. I'm not sure that's right, my lord. I'm not sure the claimant needs to know about this in advance. Does that answer your question?
Well, it clarifies your position. Yes.
Thank you.
Thank you.
In which case I move on to ground two, unless there are any other points. Ground two is about the damages which Mr. Burton can claim. Whereas it's the first time the court has considered liability of a creditor under paragraph 66, Schedule 12, the law of damages when a claimant is unable to use their car is very familiar. In my submission, there's not going to be any difference between a paragraph 66 claim, a claim for breach of contract, a claim for a tort. there is very little analysis in the judgments of the earlier courts. I mentioned this earlier, other than the bare finding that my client hadn't proven his case. Now, the big picture point is this, that Mr. Burton was unable to use his car, this is undisputed, for about a month. And he had his car in order to use it, and so there must have been some loss. The only question is, how can it be quantified? Probably worth starting with the evidence that was before the court under tab 2 of the supplemental bundle. And it's page 8, paragraphs 23 to 27. Mr. Burton says 3 things. He says it's a very difficult week. He says he spent £180 on buses and public transport and cabs for himself and other members of his family. I won't take up the court's time with the 88 pence a day. I'm not going to talk about the 88 pence a day. I'm only going to talk about the £180 and the £25 in general damages. I'm broadly going to say this was sufficient evidence as a matter of law. It shouldn't have been rejected. I'd like to start with the claim for general damages, £25 a day, because we're about to see that the Court of Appeal in Beechwood held that was the primary element of the award when someone can't use their car. This is behind tab 22. So
and the starting point is that this is post-Langdon and
Yes.
O'Connor, and therefore it's prima facie binding on this
Yes.
court.
yes,
Unless Mr. Trivedi is going to make the bold submission, which
Indeed.
I don't think he makes in his as an argument that it's per incuriam, and we
Yes.
should so decide.
I'll deal with that in reply if necessary. Yes. Just to summarise the facts, the Claimant is a professional car hire company. One of its cars is damaged. It has a pool of 64 cars. It could, and normally it did, use one of its own cars as a replacement. But out of professional curiosity, it decided not to in this instance. I think we have time, so let's start with paragraph 10, which is the decision at first instance. The judge, having concluded that it wasn't reasonable to have outside hire, could they nonetheless get damages? And the answer the judge found is in paragraph 11. And the Court of Appeal emphasises the important material, particularly B. So the first instance judge said, I'm going to award damages at the spot rate charge for a comparable vehicle over the repair period. That's what was done. Then it was appealed to this court. Paragraph 20 has the submission of counsel. I'm showing the court it's just about to be accepted. Submission of Mr. Turner is that the claim for general damages is essentially one for personal inconvenience. This calls for a jury-style assessment dependent on the degree of personal inconvenience and disruption. And then paragraphs 45 to 49, page 388, marked. There's some analysis of the case law, particularly as it relates to ships. Paragraph 45 has the summary of the principles. And the passage I'm going to place particular weight on is at the end of paragraph 48 and the start of paragraph 49.
So you're saying it's the loss of having a car available,
Yes.
and that's what the £25 per day relates to.
Exactly.
And then on top of that, you have the cost of doing something else,
Yes.
whatever it is that something else is.
Exactly. And that and a bit more, which is that the court has given some conventional weekly sums. This was a couple of years ago. As a bit of a shortcut to assessing what this inconvenience is. And I think the logic of that is that it's helpful to have a standard range. The alternative is to look up the cost of an alternative vehicle. And the MOJ says that was the only option open to us. And because that evidence wasn't deduced, I can't get my client can't claim any general damages. I mean, there are two problems with.
Sorry, just before you go on,
Please.
The data that's referred to in paragraph 49 is from
Yes.
the period 1999 to 2005.
Yes.
Is there subsequent date comparable data? Because that's obviously quite some time ago now.
Yes. So the figure of £25 was what my client, what my instructing solicitors generated by using the Bank of England inflation calculator, based on one of these figures. I think it was the figure in Mullins and Phillips. So in answer to your question, there isn't, as far as I'm aware, a new case that says it's now £25 a day. What my client did was consider inflation since 2005. And the reference, just for the court's note, is this was made in submissions at the core bundle, tab 9, page 118. £25 a day is £175 a week. So I was addressing the court on the problems of having an evidence-based approach and the advantages of the Court of Appeals approach, which is a fixed rate, give or take a bit. The first drawback of deducing evidence on how much it costs to hire a vehicle is that it multiplies the scope for argument. Now, it might be difficult to prove what the hire rate for this exactly same type of vehicle is at the same time at the right place. And there might be variations in local car hire prices. It's not realistic to hire a Citroen DS3 on a moment's notice if you live in a small town in East Yorkshire. And that sort of argument can be disproportionate for low-value claims. We are, after all, talking about £25 a day, well within the boundaries of the small claims track. Even if it was 10 times higher, it would still probably be in the boundaries of the small claims track. And the second defect with the MOJ's approach of requiring evidence of an alternative car, as opposed to the Court of Appeals approach of a fixed rate, is it can be slightly unreal, because this car costs £7,200. That's in the bundle, it's in the hire purchase agreement. But you get cars that cost £70,000, you get cars that cost £700,000, you get supercars that cost £10 million. And although you might suffer a greater loss of amenity being forced to take a bus rather than drive your £7 million supercar, it's not 1,000 times worse than the loss of amenity from being able to drive a cheaper car. And I say so because the inconvenience, which is what you're trying to measure, the inconvenience is caused by needing to wait to take a bus and not by the experience of the car. I'm not saying the court has to use this conventional rate. It acts as a jury, and its objective is to measure the discomfort caused. And in Mr. Burton's case, as my Lady Justice Asplin has picked up already, he wasn't able to simply drive from A to B as he chose. And he had to wait for the bus. in the middle of the winter in a small town in East Yorkshire where the bus services might not be great in 2021 in the middle of a pandemic. So there is genuine loss of inconvenience there.
Well,
not
except that his evidence was that he hired taxis when he needed to.
Well, yes, but
and of course that feeds into the claim for special damages. I understand that.
He didn't say he hired taxis whenever he needed to, my lord, and the sums of money involved wouldn't reflect that, because we're talking about £10 a day. He says he hired...
He said also it was difficult to hire taxis because there weren't many about,
because
taxi drivers were also affected by the pandemic.
Yes.
On furlough, he says.
Yes, exactly. He says, yeah. I mean, he gives evidence, for example, that he had to go to work, he had to shop, he had to give go to attend medical appointments. If you do all that on taxes, it'll cost more than £10 a day. And also he refers to paying for himself and other members of the family who would otherwise be able to use the car. So I accept the principle that if you hire a new car, general damages will be the same as special damages. We're about to see that in Langdon, because you're in no worse position. But taking the bus simply isn't the same. And that's clear from the decision of Sir Mark Potter we've already looked at. There's one other point I should say, which is about the respondent's notice, which is the argument that an appellant can't claim general damages for loss of use in circumstances where they claim special damages. That's the second of the 2 points in the respondent's notice. That's obviously not consistent with Beechwood, but and I'll address the Beechwood as wrong point in reply, but I would like to look at the passage in Langdon that the MOJ rely on in support of its respondent's notice for this proposition. And that is behind tab 18. So this is a credit hire case. Claimant couldn't afford to hire a replacement vehicle, entered into a credit hire relationship, paid nothing up front, and the credit hire company sought to recover more after the fact. And the passage the MOJ cite is at paragraph 27, 324, the speech of Lord Hope, page 324. And this is said to be authority for the proposition that you cannot seek both special and general damages. And my reading of this case is that what Lord Hope is saying is that in a specific type, a special type of special damages is to get a new car. And in that situation, the two heads of claim merge because you have a car, you suffer no more inconvenience. And he's not saying that as a general rule you can't do both. It's a short point, but one I have to make because it is in the respondent's notice. That takes me to special damages for £180. Where my position is, my client gave sworn witness evidence that he spent £180 on buses and taxes, and that evidence should not have been treated in the way it was.
Just on that, was there any request for disclosure of receipts by the MOJ?
Not as far as I'm aware, and certainly this is the point I'm just about to make. The judge says in their reasoning, I infer from the failure to provide receipts at the time that. I'd like to look at what the two judges say about this evidence in their judgments. Beginning with Judge Berman behind tab 14 of the core bundle. And it's paragraph 16 under page 171. If Judge Burton had found that my client was lying about £180, or somehow made an error of calculation, this appeal would need to be quite different. I'd need to show that that was a finding of fact, which no reasonable judge would have reached. And I suspect I'd have been able to do so, but that's not what we have here. What's said is that the claimant has failed to provide any evidence in support of his claim for damages. Well,
You say that's simply wrong because there was unchallenged witness statement evidence.
Exactly, the statement of truth attached. And I emphasise the statement of truth because we're talking about a small claim where, had it been allocated the small claims track, you wouldn't even need a statement of truth. Judge Richardson goes a bit further. If I could go back to tab 8, page 102. It's paragraph 56 at the bottom of page 102. The court will see Judge Burton criticises Mr. Burton for, says it's totally unevidenced, and then she specifically criticises him for an absence of receipts. Well, but this point we were just discussing with my lord, Mr. Burton wasn't asked to bring receipts, and this isn't an inference from a failure to do so. Buried within the conclusion of both judges is this unstated assumption that my client should not be believed unless there's documentary evidence to support him. Now that can be a conclusion that judges are forced to reach after they've heard cross-examination if they have a witness who's particularly unsatisfactory, absolutely within their rights to say, I don't trust them unless there's document in support. That's not how the court approaches witnesses from the beginning, and there's really no basis to reach this conclusion here. Firstly, if this is the court's reasoning, we don't trust Mr. Burton, it should say so. And secondly, his evidence that he spent about £10 a day, £13 a day on buses and taxis is totally credible. I mean, if you accept that he couldn't use his car, then it follows that he probably had to take the bus and occasionally take a taxi, and it would cost about £10 a day. Particularly since we know that he went to work and we know that he occasionally had to go to the shops and have a medical appointment. And so there's no conceivable basis for saying this evidence is false. This is a low-value claim, extremely low-value claim. The claim for £180 is about half an hour of my solicitor's time, less if you consider VAT. It's possible to file a schedule of receipts, £2.50 there, £5 there, but it's proportionate not to do so. There is one quick final point, unless any questions about special damages. It's about nominal damages.
Can I just ask you about the interrelation between general and special?
Yes.
General damages, an amount, you say, per day, to reflect that you haven't got a vehicle.
Yes, the inconvenience of not having a vehicle.
But it's accepted that that could be mitigated
Yes.
by hiring a vehicle.
Then you would have a vehicle, yes.
You would have a vehicle. So, and what is the relationship between the amount, the spot rate for hiring a vehicle, and the amount you claim as general damages?
Well, one methodology of assessing the inconvenience, it's a methodology which has the support of Langdon, but it's not the only methodology, is to look at the spot rate
Yeah.
and say that is your inconvenience because.
Then, what slightly draws me then is, if you did hire a vehicle,
Yes.
then you wouldn't be able to claim for bus fares or taxi fares
Yep.
because you have a vehicle.
Yep.
So if you're having general damages, which is equated to the amount that you might have paid to hire a vehicle, why should you then also recover for fares and taxis?
That's an interesting point, my lord. I think that supports Mark Potter and Beechwood in giving a fixed sum of around £25 a day, rather than looking at the spot hire rate. I agree with that logic. Yes. And it's particularly absurd with a high-value car, I think, where it simply isn't that inconvenient not to have the car. It's not twice as inconvenient, it's not 10 times as inconvenient if it's a particularly high-value vehicle and the spot hire rate is enormous.
Forgive me, I'm not quite understanding where you're coming out on it, though.
Well, I was agreeing with the logic and saying that rather supports my analysis, which is to rely on Sir Mark Potter to use a fixed figure. The court
a fixed figure, but then nothing extra for special damages.
No, the Court of Appeal said plus. I don't agree. The court said the fixed
So the
figure.
assumption is that the conventional rate
Yes.
will be lower than the spot rate. And I mean, he doesn't say that in terms, but what you're saying, I think, is that one explanation of that is that the difference reflects what you actually spend on substitute forms of transport.
Exactly. Thank you.
So if during the period you were a very heavy user
Yes.
of transport, alternative transport,
Yes.
that would probably reduce your general damages.
If you're a very heavy user of public transport already.
Well,
yes.
no, I mean if you
You never use the
in
car.
substitution, you use taxis heavily,
Or I see taxis rather than buses.
or
yes.
buses, well, whatever you use.
Mhm.
Presumably, the more you use those from the transport, in a sense, the less inconvenience, general inconvenience there is from not having a car.
In a sense, the reason I would distinguish between buses and taxis is because one is a more convenient form of transport, it's also more expensive. But,
And we're talking about very small sums of money in this case, but as a matter of principle, it's quite important.
Yeah, I agree. I agree, but I'm only asking the court to follow, give or take the inflation adjustment, the analysis of Sir Mark Potter. But I agree it's an important
Who says
point.
you should have both?
Who says you should have both? He says, you can turn to it, tab 22, page 389.
Page 389.
389. He says, and this is at B, in the latter case, so the court's meant to be acting as a jury, albeit the court may be concerned with the degree of compensation for fares, etc., by way of special damage, in a case where the owner has been obliged to use public transport rather than his damaged vehicle. The primary element of the award is that of compensation for non-pecuniary loss, i.e. the lack of advantage and inconvenience caused by not having the car ready at hand at all hours of personal and or family use. So yes, he says, you get your special damage, you get your bus fare, your £180, £10 a day, whatever it may be. But the primary compensation is it's just not as good to go out to the bus stop.
But as my lord says, if you have a case of a claimant who is able to and does hire a lot of taxis, then that must impact on the general damages award, mustn't it?
Yes, because it would be less inconvenient, yeah. Another example might be, someone who suffers an injury, is in hospital for the month. When they come back, their car has been returned to them. In that case, they haven't used their car at all, couldn't have done. Maybe they don't get any general damages because they haven't suffered any inconvenience. The point is, the court sits as a jury, says how inconvenient is it, and there are different methodologies. And the one promoted in Beechwood, Birmingham, which, as I'd argued, is in many ways preferable to that of an evidence-based spot hire approach, is to say a fixed sum plus special.
And here you would say the evidence is this gentleman had to go to work, etc. And he was doing so during a pandemic, when not having your own car is extremely inconvenient.
Yes, exactly. And
He doesn't say he was going to work, does he?
Yes,
He
I think
says-
it does.
He was a self-employed consultant.
he says, paragraph 23, supplemental table.
Very high taxi costs in order to attend work.
Exactly.
Tent work, that's how it is.
We know his date of birth from the other documents in the bundle, and he's of working age.
So which paragraph is that?
23 on page 8, the very top one. Let's say something very briefly about nominal damages, and then I'll conclude. It won't take me long, because there's a degree of agreement between me and my learned friend about nominal damages. And we agree that a tort against goods is actionable per se. That is to say, there is an automatic entitlement to some sort of compensation. My learned friend, the MOJ, says that, and I'm quoting from paragraph 42G of the skeleton argument, while trespass against goods is actionable per se, paragraph 66.2 of Schedule 12 states that the breach or defect does not make the enforcement agent or the person who's acting for a trespasser. So this very last point I'll conclude, which is look at paragraph 66 one final time. That's behind tab 6, page 82.
Mm-hmm. 66.2.
66.2 is what the MOJ say means means that there is no longer an action or claim in the absence of loss, which again comes down to the construction of 66.2. I would say that this can only be referring to trespass to land, and we know that because most breaches of Schedule 12 are themselves torts against goods for the most part. And you can get damages for that under paragraph 5. So whereas 2 says there can never be any cause of action whatsoever in trespass, it could only be a trespass against goods.
Well, then the cause of action is a breach of statutory duty.
It is a breach of statutory duty, which is which is a
Tort.
Which is a tort. And but what's gone wrong is a trespass. In many cases, it would be a trespass against goods when you're talking about taking control of goods. And with that point,
But you would say if that is the construction of subparagraph 2, then 5 is almost dead in the water.
exactly,
Or they're inconsistent with each other.
exactly. And that concludes my submissions on ground 2. In essence, the lower courts were wrong to quantify the loss at 0, given the evidence before them. And so, unless there are any other questions on ground 1 or ground 2,
No, thank you. Thank
Thank
you
you.
very much. Mr. Trivedi.
Yes, my lady, thank you very much. I mean, given the time, I'll start with at least an introduction as to ground 1 and progress it accordingly. The ultimate submission of the Ministry of Justice on ground 1 is that the first appeal judge was squarely wrong in finding that Deputy District Judge Burton and the first appeal judge they were correct in finding that in order to hold the Ministry of Justice in their capacity as a creditor, I'll come on to that a bit later on, liable for damages under paragraph 66, the creditor must have caused or contributed to the loss. And I say that loosely, it's the breach essentially that essentially led to that loss. So in other words, there is no joint or several liability that's imposed upon the creditor, and that this case is distinct from that in Bone and Williamson, which dealt with a writ of control that was directed to the High Court enforcement officer. And I'll come on to the definitions of the powers under Schedule 12. But the enforcement power was, in that case, directed to the High Court enforcement officer by way of the writ. It's the writ, in this case the warrant, that confers that power. And in that case, the distinction really is that that power is conferred on the High Court enforcement officer, who then conferred it on to the enforcement agent. In this case, the difference essentially is there is no conferred enforcement power upon a creditor, and that the court, in this case, the magistrate's court that issued the warrant, by that warrant it was conferred directly upon. And there is a bit of a distinction here, because the case in the lower courts proceeded on the basis that the enforcement agent is to whom the warrant was directed. I have taken instructions because I appreciate there isn't a warrant, unfortunately. But the position is that it's directed towards Marston's enforcement agency, who, and I'll come on to the contract.
And choose a person.
Who choose a person, my lady. That's absolutely
So
correct.
it's directed to Marston.
Absolutely.
Thank you.
Well, you say that, but that's the first we've learnt of that.
Yes.
And how on earth are we supposed to proceed on that factual basis when that's never been suggested before?
I appreciate the concern, my lord. The only thing I can say is it is an instruction. I can't give evidence. I'll take instruction at lunch as to whether or not there is some material available for the court to look at. Obviously, I'll pass it on to my learned friend.
Well, this all comes back to the astonishing inability of your clients to produce the warrant.
Yes, my lord.
Which is absolutely staggering.
I appreciate it, my lord. It presents difficulty, at least in determining to whom it was directed. Of course, I can't mislead the court. I've been instructed that that is the position. My learned friend is. I'm in your hands as to how I approach it. I could approach it as the basis of an agreed fact. I don't know if it is an agreed fact.
We don't know, because we haven't seen the warrant.
And they've been asking for it for a long time.
I appreciate it, my lord. It does present a difficulty. I can't see it any other way around it apart from that's my instruction.
Marston isn't an enforcement agent.
No, it's the agency. It's the approved enforcement agency. So we have the contract in the bundle.
So how is it validly issued to Marston's, if indeed that was the case?
My submission would be under Schedule 12, and I can, whilst we're on the point, I can quickly address it. So in the authorities bundle, I believe it's tab 6.
Yes.
Let's find the particular paragraph. Actually, a short way to circuit this, actually, if we go to paragraph 66 of Schedule 12, which we have at page 82, we do know that under subparagraph 6, that a rated party could be the person on whom the enforcement power is conferred. The reference to person could be Marston's enforcement agency in my submission.
If different from the enforcement agent.
If different from the enforcement agent. And the agency would be different to the enforcement agent, otherwise. In my submission, there's nothing stopping.
Yeah, well, I take that point,
Yes.
but I don't understand how that provides an answer to the question I was asking, which is how can Marston's be validly conferred the enforcement power if they are neither an HCEO nor an EA?
There's nothing, my lord, in the legislation which states that the enforcement power must be directed to an agent or the HCEO.
What about Power 2?
Is that paragraph 2 of Schedule 12, my lord?
Yes.
Only an enforcement agent may
Yes.
take control of goods.
Yes, that was a contention in Bone. The use and the conferment of that power are slightly different. So the enforcement agent under that definition can use the power. So in the case of a High Court writ, for example, as in Bone and Williamson, we have a High Court enforcement officer to whom the writ is directed. Therefore, there's a conferment of the enforcement power upon the High Court enforcement officer, He can't use that power, but only the agent can use the power. So the use isn't of any difficulty, I would submit, on the respondent's case, in terms of whether or not Marston's whether a warrant can be directed towards Marston's. In the same way as a High Court writ can't be enforced directly by the High Court Enforcement Officer himself, i.e. using the Schedule 12 powers, Marston's can't either, but they can forward that on to the enforcement agent and confer that power on further.
So you'd say that was consistent with Schedule 12, paragraph 2, sub-paragraph 3, an enforcement agent, if he is not the person on whom an enforcement power is conferred, may act under the power only if he's authorised by that person.
Absolutely.
So you'd say enforcement power on Marston's authorises Mr. Allen.
Absolutely.
All right, well, that's helpful, thank you. But from what statutory provision is the enforcement power derived?
There's a definition of what an enforcement power is. I believe it's just, it's one page up in the authorities bond at page 70. So paragraph 1, subparagraph 1 states, using the procedure in this schedule to recover a sum means taking control of goods and selling them to recover that sum in accordance with the schedule. And then subparagraph 2 confirms that in this schedule, the power to use the procedure to recover a particular sum is called an enforcement power. So therefore, the warrant confers the enforcement power because we know that that's what it states. That it's the warrant of the writ conferring the enforcement power to be used by the agent. But there is nothing further than that in terms of the definition.
All right.
So the power can be conferred on anybody.
Maybe that might be the case, but in terms of the practical position on the ground, it wouldn't be. The warrant would be conferring it on in this case, there's obviously a contractual arrangement upon the agency who then forwards it on to the enforcement agent. I can't see anything within and I have looked, to say whether that there's a limit to whom the power can be confirmed to. But what I do know in this case, it is based on instruction directed towards the agency.
But that seems very strange, because the best evidence we've got, in fact the only evidence that we've got, is the so-called copy of enforcement details. I mean, what that means is a mystery. But we have it in the supplemental bundle, tab 28, page 314.
Yes, my lord.
And this tells us at the bottom of the page that it's not the warrant of control, the original of which is held by HMCTS, and yet apparently HMCTS are completely unable to produce that original, which we're told that they have. And we know it can't be the warrant of control for many other reasons, not least the fact that it's dated the 4th of June 2021, which is well after the enforcement action. So at best, this is secondary evidence of some description of the warrant of control. But if we look at it in the middle of the page, it says to each and all of the enforcement agents and authorised officers of approved enforcement agency. That seems to be the only evidence we've got as to whom it is directed. And would you not accept that that language seems to encompass every enforcement agent and agency in the land?
I accept this isn't the warrant of control. That is correct, my lord. And I accept what is stated in the middle. There's that it does say to each and all of the enforcement agents and authorised officers of approved enforcement agency. My submission is approved enforcement agency is Marston's, but it doesn't. It is vague.
It might encompass Marston's.
Yes,
but it's not exclusive to Marston's.
No.
Not only that, the language includes Mr. Allen, does it not?
Yeah, it does. It does, my lord. That's the evidence we have. That's the evidence that's before the lower court. Of course, I am presenting a difficulty because on instruction, that's not the case of the Ministry of Justice on instruction. There's unfortunately only so much I can say in that respect because there is a discrepancy there. as I say, in my submission, if it is on instruction Marston's that the warrant is directed to, doesn't present a difficulty in terms of analysis, because ultimately the enforcement power was conferred upon the enforcement agent anyway.
Well, quite, yes. It's he who actually has the power to take control of the goods.
Absolutely.
Yeah.
So I don't, in my submission, it doesn't really affect the analysis in the case, other than the fact that this is an agreed position, that Marston's are an approved enforcement agency, and they are the ones who are subcontracted by way of an enforcement agent. In this case, Mr. Allen. If I may, with permission, move on from that unfortunate issue. I'd like to start from the policy reason standpoint as to why I submit that causation or contribution towards loss and the breach is required, because it's critical that the Court of Appeal considers the position of a creditor, generally speaking, and this was considered early on in response to my learned friend submissions. Paragraph 32 of my skeleton addresses this. First and foremost, if the law is anything other than but the requirement for causation or contribution, say there is joint and several liability, an automatic liability in paragraph 66, and that's a blanket law against all creditors. It's not just the Ministry of Justice.
Well, I understand what you say about the policy, but before we get to the policy, how do you get this out of the language?
Language of paragraph 66.
Indeed.
If one turns back to page 82 of the authorities bundle, so we have here that the paragraph applies where an enforcement agent breaches a provision of the schedule or acts under enforcement power that is defective. We're concerned with paragraph 66(1)(a). We know that the breach or defect does not make the enforcement agent or a person who is acting for a trespasser. So that's the first obstacle there, I appreciate. The person who is acting for. My submission, where there's a writ of control, that's clear, it's the High Court enforcement officer. Other than that, in this case, there isn't a person that the enforcement agent is specifically acting for. On the Ministry of Justice case, it will be Marston's. Marston's are the ones that are subcontracting out these enforcement agents. It's not the Ministry of Justice as creditor that's instructing the enforcement agent. It's Marston's. And we know this from the contract itself that's been now adduced into evidence. It's at the bottom of that authorities bundle.
So, on that hypothesis, the creditor could be a trespasser.
My lord, in what respect, if I may ask?
Well, your submission is that in circumstances such as we have, a person he is acting for, it refers exclusively to the agency. But then that means there's no protection for the creditor.
In my submission, the creditor doesn't fall within the remit of that, because there is no relationship, my submissions, which I'll come on to, between a creditor and the enforcement agent. So there would be no liability on the part of the creditor anyway. They are not the principal to the enforcement agent. So the contract is actually within the supplementary bundle. It's at tab 27, page 276 onwards. And it's worth noting that this is a contract for the provision of approved enforcement agency services between the Lord Chancellor, so on behalf of HMCTS, and Marston Holdings Limited. We turn the page over at 277. The Lord Chancellor is described as the authority, and Marston Holdings Limited as the service provider. They're providing a service of of enforcement essentially to HMCTS.
I'm sorry,
Bear
I
with the
was.
court whilst they turn to the right page. It's
Yes,
276.
I was looking at it in the application, but let me find the right page, please, in the supplemental bundle.
Yes, 276.
Thank you. Sorry about that. Yes.
So as mentioned, so it's between the approved enforcement agency, Marston's, and the Lord Chancellor on behalf of the HMCTS. Over the page, the description of Marston's is service provider.
Yes.
And what we have,
But we don't seem to have clause A3, which we know from the index deals with service provider's status.
we don't in this extract, but whilst, my lord, you have raised the point, I have the full document, I can read out A3.1. It may help.
Right.
If it's this, I did actually print out the full contract in case someone's going to ask questions. So I could hand up.
Oh wow.
It's quite
Well,
a...
if I have it.
Yeah, I've got one for you too, if you read it.
Right, well, let's have the whole thing. It makes
Absolutely.
sense.
I only printed off the first schedule. Because,
You mean there's even more of it?
sorry.
That's amazing.
Let's one of each. Do you want one?
Thank you.
And that's the schedule.
Thank you, Mr. Kinslow.
Very lengthy document, unfortunately, but A3.1 will provide services.
Thank you.
Thank you very much.
I believe it's page 25 of that document.
Thank you.
So what we see at A3.1 is the service provider, the Marston, shall be an independent service provider, and nothing in the contract shall create a contract of employment, relationship of agency or partnership or joint venture between the parties, and accordingly neither party should be authorised to act in the name of or on behalf of or otherwise bind the other party, save it's expressly permitted by the terms. There's nothing I've seen that does that, but that makes very clear that that service provider is an independent one, and it's essentially a service provided by the name itself. It's providing a service. It's not acting on behalf of HMCTS.
And then A3.2, service provider shall not say or do anything that might lead any other person to believe that the service provider is acting as an agent or employee.
Absolutely. And no argument of ostensible authority is being raised to suggest there's an agency relationship in this case in the lower courts or otherwise. So it's those provisions, and importantly, that's the relationship obviously between Marston's and HMCTS, and then we have further provisions that deals with the relationship between Marston's and its enforcement agents, and that was described in my scheduled argument in respect of the application. If I just pull that up,
Well, which provisions in the contract is it?
it is F8.6 and F8.20. Page 57. Firstly, for F8.6.
Yeah, but
You see,
don't
that,
we need to find first of all where the service provider is empowered to use subcontractors?
yes, we do.
I assume that's earlier in
It is.
this.
7.2?
Apologies, my lord.
Sorry.
There is a provision within it, but
So it's for F8.1, is it? That refers, in fact, to Schedule 9.
yes, that whole of F8 does deal with subcontracting.
I mean, it's obviously implicit that it does have power. It's just that I was kind of assuming that there would be some, given that this is hundreds of pages, apparently, with all the schedules, that there would be some specific provision saying that the service provider can subcontract.
For exigencies of time, if I may be, I can have a look at it at lunchtime and locate it, but
Yeah, it's not that
assumed
important. It's not that important.
No, thank you, my lord. But F8.6 and the other provision, F8.20, essentially say the same thing, that the service provider, Marston, shall be responsible for the acts and or omissions of its subcontractors as though they're its own. F8.20 confirms that as well, that service provider shall remain responsible for all acts and omissions of its subcontractors. So what we do know from this is that there's an agency relationship between Marston's and its subcontractors, but there's no direct relationship of any agency between the creditor MOJ or HMCTS and those enforcement agents operating on the ground. Nor is there an agency relationship between Marston's and HMCTS under the terms of its own contract. So when one goes back to paragraph 66, page 82 of the authorities bundle, the person he is acting for under subparagraph 2 in my submission could only be Marston's in this case, in terms of the enforcement agent, not the creditor. And that, answering my lord's question earlier, that does not make the creditor in this case liable because they're not acting, the enforcement agent's not acting for it. We skip subparagraph 3 and 4.
Sorry, can you help me on this? Why is the enforcement agent not acting for the creditor in enforcing the debt?
It's active for Marston's who have been instructed to the public function of collecting these criminal fines has been contracted out to Marston's to do, as that's the service they're providing.
Well, on the facts of this case, but looking more generally at the, you've already made the submission, which I think must be correct, that we must construe these words not by reference to the facts of the individual case, but on their general application. Yes. And this is all about creditors enforcing debts. Now, why is the enforcement agent not acting for the creditor? I don't understand.
There's 3 submissions that or the main submissions, which is set out in paragraph 29. One is because the enforcement agent is not an agent of the creditor, generally speaking. They are an officer of the court, and I appreciate my learned friends made submissions on that, but that's the position of the Ministry of Justice. That creditor can't be a principal to the enforcement agent under the principles of agency. And at least when it comes to self-employed and certificated agents, there's no vicarious liability either or an assumption of responsibility.
Can I ask you this question? Is it your submission that the words acting for excludes an independent contractor? In other words, you seem to be submitting, if I've understood your submissions correctly, if I've misunderstood, please correct me, that acting for is confined to an agency relationship and therefore would not extend to a relationship of independent contractor and the commissioner of the independent contractor.
The independent contractor in this case would be the enforcement agent.
Yes.
The person he's acting for would be the principal to that enforcement agent, in my submission. The person he's acting for.
All right, but I'm still not quite sure I've understood what your submission is as far as the language is concerned. Are you saying that acting for is confined to an agency relationship, or do you accept that it could extend further?
My submission is an agency relationship.
You can make this point, can't you? Is that whenever there is an enforcement agent taking control of goods, there will be a creditor.
Yes.
So it's a very odd way of dealing with it, if the person he is acting for is meant to be a creditor, it's very odd not to say so.
Absolutely.
It would be very simple to say, does not make the enforcement agent or the creditor a trespasser.
Absolutely, my lord. And there is already a definition of a creditor. They could have adopted that. They have not done
So it has to assume that the person he's acting for, whilst theoretically it could include a creditor, it doesn't necessarily have to be a creditor, otherwise the statute would simply have said so.
Absolutely.
But
And there is
what would
express
you
definitions. So why the Parliament has decided not to adopt it here would suggest that very thing. That
Well,
it's-
fine. It's not limited to a creditor, but the fact that it's not limited to a creditor doesn't exclude creditors, does it?
I appreciate that. But
I think the argument put forward by the appellant is that whilst it might include other people, it always includes the creditor automatically. So if that was right, it's not clear to me why the statute wouldn't have simply said so. And that also applies to the way it's dealt with in subsection 6. I mean, if a creditor is automatically liable for the coterminous liability with the enforcement agent, why doesn't it say so?
Absolutely. There's a definition there. In my submission, it's limited to the agency relationship. It has to be. Otherwise, there would have been the words the creditor, which isn't used in subparagraph 2, but is in subparagraph 6. So in my submission, there is a limit to it, albeit there isn't a specific reference to the creditor there, or an agency.
I mean, if what this amounts to is whatever the enforcement agent does without a reasonable belief, the creditor is by statute, never mind vicarious liability or otherwise, is automatically liable. It's a very odd way to do it. If that's what the intended outcome is of these provisions, and in particular in 5B, to say the enforcement agent or a related party. Well, on the appellant's argument, that is bizarre, because in fact it is the enforcement agent bracket and therefore also the creditor close bracket.
Absolutely.
And why would you have the disjunctive or?
If it was to be clear, there would be. There wouldn't have to be. That's the issue. When I was coming on to my earlier submission, that the legislation in paragraph 66 it appears to be quite absurd in that sense, because if there isn't a causation requirement, it goes against those policy objectives. One also looks at subparagraph 8, that where there is a reasonable belief on the part of the enforcement agent that it completely wipes out the liability of even the creditor. In my submission, that's absurd as well. One could get around that, and it would have been one of my later submissions, that if that's tailored towards the enforcement agent himself and his own liability, not the creditor, albeit the language would appear to suggest otherwise. And if there was a debtor's had a grievance directly against the creditor alone, could always bring a Part 7 claim for any other tort that's applicable, which could even include a breach of statutory duty in that respect as well. But that's not. It's a very confusing piece of legislation.
All right. And you were going to tell us how you construe paragraph B.
So paragraph 2, do you mean, my lord?
No, 5B, 66 5B, because you've told us already that your submission is, and we understand this, that somehow one reads in the words cause or contributed. But can you explain to me how you read those words in? I mean, the starting point is we know that there's an express requirement of causation, because it says loss suffered by the debtor as a result of the breach. So that's plainly a requirement of causation, yes?
Yes.
So your submission is that there's some unexpressed requirement of causation in the language, and where do we find that?
Well, we see as a result of the breach, it's paragraph B. That's where I peg the Ministry of Justice case. It does require some element of causation in respect of loss suffered by the debtor as a result of the breach or of anything done under the defensive instrument.
It's undisputed that Mr. Burton's loss was as a result of the breach.
My submission extends to, therefore, the creditor as well. The creditor must have caused or contributed towards that breach in order to be liable. If there was no causation requirement in my submission, any creditor who simply goes to enforce his judgment, someone on the street who simply has got a judgment debt of a low amount, he goes to court, asks the court, I can't enforce this judgment. I haven't got payment. I need someone to enforce this. The court goes, we'll send out a warrant if you want us to, yes. And then the enforcement agent goes on a frolic of his own. A creditor will be automatically liable. And in my submission, that's an absurd reading in my submission of paragraph 6.
I understand what you say about the policy, but at the moment I'm just trying to understand your submissions on the language. And let me see if I understood what you said correctly. What you submitted, as I understood it, is that you say that when it says loss suffered by the debtor as a result of the breach, that language not merely requires that the loss be caused by the breach, but also requires that the related party have been the cause.
Yes, my lord. I appreciate it's a difficult construction. It's the only construction I can get to. I appreciate that.
So I have difficulty understanding why you're pinning this on causation. I mean, usually, if there is something required, it would be some element of fault, wouldn't it, rather than causation. You have to have the fault before the causation.
The fault would be the fault on the part of the enforcement agent, so it's contributing to the way in which he is in breach of Schedule 12 in some way, shape or form.
But as the point's been made, in a strict but for causation sense, creditor does cause it because he has appointed them.
Well, in my submission, the court's analysis shouldn't start there. It starts at the point of the breach itself, not just because a creditor goes and issues a warrant. That doesn't cause the breach. The breach is caused by the enforcement agent who goes out and does the work. Therefore, in my submission, the analysis doesn't start there. It would start at the point of the enforcement agent conducting his Schedule 12 powers.
So it's caused or contributed to the breach.
Yes.
In a blameworthy way. Is that right?
I deal with causation and the requirements for the same in my skeleton. Paragraph 41. So yes, there has to be. So what I put is the claimant must show that the defendant's wrongdoing or some form of negligence caused them actual damage. That's what happens. The majority of torts, the usual tortious rules would apply. So there has to be some element of fault on the part of the creditor.
Well, as my lord points out, we need to distinguish between fault and causation. And your own submission is that the ordinary tort rule of causation applies. Would you not accept that the primary rule of causation in tort is the but-for test?
It is, but in my submission, the but-for test, if fault is required, the fault isn't handing out a warrant and asking the enforcement agent to enforce it. It doesn't begin there. It would start at the point of the enforcement agent doing the wrongdoing itself. Or if there's, for example, there could be a tort of malicious execution or otherwise the incorrect giving of information as to how much is owed under the warrant, or the judgment's irregularly obtained, which is some of the elements I referred to in my skeleton. In those situations, you have fault, so you can see why the but-for test or causation, or at least what I've put here in terms of the other forms of test for causation, material contribution to the loss, why those would apply. But it wouldn't apply simply because a creditor asks the enforcement agent to enforce the warrant, or the warrant is taken out by the creditor, because there is no blameworthiness on the part of the creditor for doing that.
Do you accept that if the agent has been appointed under a writ by a High Court enforcement officer, is the HCEO automatically liable for the enforcement agent's breaches.
Well, Burton Williamson has decided that.
Yeah.
Yes. So that would be a correct proposition of law.
So that is a related party who is liable under 6A without fault automatically.
Yes. From Burton Williamson, that is the case.
So why is a creditor any different?
Well, in the case of Burton Williamson, as I discussed, in that case, and my learned friend turned to the actual discussion of it in the judgment. If I may just turn to it in the authorities bundle.
I think, given the time, perhaps we should turn to that at 2 o'clock.
That's fine.
I was concerned not to butt in relation to this because this is the heart of the matter. But I think that we need to take a break.
Thank you.
2 o'clock then.
All right, people. Please just remind the courtroom that the